Hello, to see if this actually is working. And yeah, 1 second, sorry. Just making sure that things are working and things are visible. And yeah, um, yeah, so things okay. Um, we are actually covering today a case from the UK. So because um US at the moment is a little bit stopped and everything because it's kind of Christmas time. There's hearings only kind of going on. There's not many trials at the moment. So what I thought we could cover this case today. This happened just like a brief overview because we have a lot to catch up. So this happened last year and almost a year ago today, actually. Well, not more than a year ago today. And um yeah, so happened a year ago today, about like November time. I think it was. Let me check my notes. Sorry, I do have it written on the 2nd of 11, so 2nd of November 2023. This case happened. So the girl that you see on the screen, her name is Brianna G. She was a 16-year-old transgender 16-year-old in the UK that she got unalived by two teenager, Scarlett Jenkinson and Eddie Ratcliffe. So they unalived that. There is footage that we're gonna watch. First is we're gonna watch some footage of the investigation. For example, this is from the news source, Sky News, that we have. And then we're gonna see the body camera of the arrest where Scarlett and Eddie get arrested. And then the third video that we're gonna watch is the sentencing of them back in February. And then the third one is the longest one, so it will increase in time. And the third one is going to be the appeal of the sentence for Eddie, the guy that is in the thumbnail. So that's how we're going to be playing out today. The whole situation. Just to give you awareness, a heads up, my internet has been having issues lately. I am talking with my internet provider. It's getting fixed. Hopefully the new thing comes tomorrow to fix it. But if the stream does fail, I will restart again on another stream. So just to be aware, if it freezes, it's probably not you. There's a big probability it's me, but I will check. Good morning, Denise. You made it. I was just telling a little bit about the case. I haven't said much, but the videos that we're gonna watch, they explained the case in itself, but I found this case quite interesting, and it was kind of a shock for us over here. So I'm gonna play this first video, and then we're gonna go from there. Right, this one. Hopefully it sounds fine.
When Brianna Jai left home on February the 11th, it was to be for the last time. An anxious teenager who rarely went out alone, she messaged her mum that day, "I'm on the bus by myself. I'm scared," she wrote. Her mum replied, "That's well good." She was proud of her, she said. That last message, though, the last Brianna's mum, Esther, ever sent her, it seems she never read. Because there were other plans that day, the plans to kill Brianna, spelled out in this handwritten note found crumpled on a bedroom floor, with a smiley face and a heart in the top corner, the date and the victim, and the details of how she'd be killed. It laid out how she'd be led to Linear Park in Culcheth in Warrington, and what would happen when they got there. It was, the prosecution said, exactly what ultimately did happen.
On that Saturday afternoon, a couple were walking on this path when they saw two people bending over, they said, as if tending a dog. As they got closer, they realized it was, in fact, the bloodied body of a young woman, face down in the mud. It was Brianna Jai.
Brianna died as the result of a sustained and violent assault, stabbed 28 times. She was pronounced dead in that park. The court saw messages between her two killers in the weeks before, in which they discussed killing other children as well. They initially planned to kill Brianna 2 weeks earlier, when the girl messaged the boy to say she's agreed to come to Colchester tomorrow. The boy replied, "So I bring my knife?" The girl said yes. "Is it definitely sharp enough, by the way?" The girl then sent a message to the boy saying, "Meet me at the wooden posts in Linear at 12. We'll go over plan again, and I'll show you where I'm killing her. And then we both walk to the library to meet her. And grab on to Brianna, slit her throat. When she starts to fall, stab her in the back. Then pass me the knife. I want to stab her at least once, even if she's dead, just 'cause it's fun. Lol." The boy then said, "Let's have 2 words, one for getting the knife ready and another to stab." The girl replied, "For get knife ready, I'll look at you and cough, and to stab, I'll say gay." After Brianna's death, the girl posted this tribute, calling her an amazing friend. In fact, the court heard she and the boy were preoccupied with violence, torture, and death.
That thirst for kill from 2 15-year-olds, that was really disturbing. We still do not know to this day why they've done it, what sort of led them to want to do it. Obviously now they've played on the fact that they thought it was a fantasy, but when you read those messages, it was quite clear that was a plan, that wasn't a fantasy.
Brianna was 16 when she died. The court heard that although she was born male, she was living, dressing, and referring to herself as female. The girl who killed Brianna was fascinated by her. The boy referred to her as it.
The loss of her young life.
In the days that followed Brianna's death, dozens of vigils were held across the country in her memory. A teenager who thought she was just going to the park for the afternoon, but who instead met the most horrific of deaths. Greg Milam, Sky News.
Scarlett, this is what I've got to say.
Yeah.
At this moment.
Oh, sorry. So now this second video is the body camera of the arrest of Scarlett and Eddie, the analyzers of Brianna. So let's just watch.
Because the information I have received, you are under arrest on suspicion of murder. Obviously, you are under caution, so anything you say is getting recorded. Okay.
Confirm me being suspect is because I was the last person seen the role. How come suspect?
Pardon?
How come I'm a suspect?
How come you're a suspect?
Because I'm the last person seen, or is it?
I don't know. All the information I've received is you are a suspect. Okay, for the murder.
Yeah. You Eddie?
Yeah.
Eddie, you're locked up suspicion of murder, all right? You don't have to say anything, but you may harm you eventually mention when questioned. You later on in court, and if you do say evidence, do you understand?
Yeah. Well, let's unlock these.
I can explain it.
Listen.
Right, listen.
Do it all on interview, all right? You're going to take it to the wrong corner, you'll be interviewed about it, they'll ask you questions, all right?
Yeah.
Okay, now it's just some like footage from the interview. There is no audio on this one, and then there's just some more footage released of where the whole situation. So the X and the Y on the screen is Scarlett, and Eddie is the Y, and they're meeting Brianna, that is the one with the white hoodie. Morning, Lewis. Welcome in. So we're just watching some footage first of what happened, of the case that we are discussing, and how they lured Brianna, the victim in this case, and then so this is just some of the footage of the body cameras of the arrest that there was in the case and everything else. And now they had a case. They had obviously a ton of evidence, and yeah, it is a very awful case. After the trial, and I think they pled guilty. They've eventually pled guilty, and they got sentenced earlier this year in February 2024, which is what you see now on the screen. That is part of their sentencing. They got sentenced together. I think 2-in-1 sentencing, because they were both charged of that crime. So what the plan now again is, we're gonna watch the sentencing, and then we're gonna go to the appeal hearing. Just to let you know, Lewis, since you just came in and I have, excuse me, the mic unmuted. If my internet goes down, just come back. And because I'm having issues with my internet provider, but hopefully by tomorrow is going to be fixed. But yeah, just come back, because I'm going to restart the stream once the connection is back up again. The reason was because Brianna G was a transgender, 16-year-old. So she was a boy wanting to be a girl. And they were not, Scarlett and Eddie, the killers, they were not in favor of that. They were against that, so they lured her and stabbed her 28 times. So yeah, it's a very awful case. That's why the distressing content is there, because it is a very sad and horrible case. But well, we all, sadly, what we cover most is a horrible case, but they got caught. They are getting the sentence that they deserve. And yeah, I know it is horrible. I choose my cases very carefully, don't I? Apparently I do. But right, let's get on with it and just watch the sentence.
Scarlett and Eddie, for Brianna's murder, you are to be detained at His Majesty's pleasure. As you know, that is a life sentence. I must also set the minimum time before you can be considered for release. But how long you will actually serve will not be decided today. You will only be released if, in the future, it is decided that you no longer present a danger. That decision will be for the parole board. If you remain a danger, you will serve very much longer than the minimum term and may never be released. But you are very young, and it can only be hoped that you will work hard at your rehabilitation and overcome what caused you to kill so that you can be released one day. Before I pass sentence, I need to explain how I have decided on the minimum terms. It will take a while to explain everything. You may not take it all in straight away, but as soon as I've finished sentencing you, I will give your legal teams written copies so that they and your intermediaries can explain anything you have missed. Brianna was only 16 years old when she was killed. She had her whole life ahead of her. Brianna had some struggles that made her vulnerable, but she was supported by a loving family who wanted nothing but the best for her. Sadly, no one will ever know what she would have achieved in her life. Even though her life was so short, she made an impact. Her family remember her for her laughter, for being full of life, and as a good listener. Their loss is unimaginable, but they have bravely and movingly painted a picture of Brianna in the statements read today. They have my deepest sympathy. Scarlett and Eddie, you had been good friends from when you were 11. You were 15 when you killed. You, Scarlett, met Brianna when you moved school in October 2022. You got to know Brianna, and she believed you were her friend. Brianna suffered anxiety and was nervous about going out. But on the 11th of February last year, you got her to meet you in Linear Park. For all her fears, she could not possibly have known you were a danger to her. But you too had been plotting to kill her and did so that afternoon. I don't want to dwell on the murder itself, but it was brutal. The injuries inflicted with the knife Eddie had bought a few weeks earlier were awful. There were 28 deep stab wounds to the head, neck, chest, and back, some causing bony damage, showing considerable force was used. There were also other injuries, not themselves fatal, but inflicted while Brianna was still alive. Defensive injuries to the arms show that she had tried to defend herself. One wound passed right through the upper arm, and another left the wrist gaping open. There were other lesser stab wounds and cuts. Taken together, the injuries point to a sustained and very violent assault. Sadly, Brianna cannot have lost consciousness immediately, and she must have been aware she was being attacked. Murdering Brianna was a joint plan which you carried out together. Both of you told lies to the jury, which they rejected. Scarlett, you make up stories. You blur the lines between fantasy and real life. When Dr. Church saw you to prepare a report for today's purposes, you told him that Eddie had thrown Brianna to the floor and stabbed her 3 or 4 times, then panicked and said he did not want to kill her, so you snatched the knife off him and did it yourself. You have repeated similar accounts to others, but with variations. Today, I am now told that you say Eddie inflicted most of the wounds, but you admit enjoying your part in the murder. The untested new accounts Scarlett has given since trial do not change my view of the evidence at trial, which is what I base my findings of fact on. It is simply impossible to believe any account Scarlett gives. I am certain that at least some of the wounds were inflicted by you, Eddie. You had blood on your clothing, as would be expected if you stabbed Brianna while she was already bleeding. Scarlett's jacket did not appear to have Brianna's blood on. In her pre-sentence report, she tried to explain that by saying it had been washed, but other evidence suggests otherwise. There was conflicting expert forensic evidence. I had the chance to assess that evidence. I have weighed it carefully alongside the other available evidence, including the messages that show that you, Eddie, were planning to stab Brianna with your knife. Beyond being sure Eddie inflicted some of the wounds, I cannot be sure precisely who did what. That does not matter for today's purposes. I sentence you on the basis that both of you played a full part in killing Brianna and both intended she should die. I must follow the principles in Schedule 21 of the Sentencing Act 2020, with reference also to the guidelines for sentencing children and young people and those with mental and developmental disorders. I have treated each of you as individuals. I have thought about all the evidence I heard during the trial and the many reports I have read about you. This case is unusual and it has shocked the public. I have thought very carefully about the features that are relevant to sentencing. One of the most important features is your age. The law recognises that children and young people are to be treated differently from adults. The minimum terms that I will impose on each of you will be much shorter than that which an adult would receive. The messages you exchanged and the contents of the notebooks found in Scarlett's bedroom show a clear plan to kill Brianna and other people and provide insight into your minds. Before reaching any conclusions, I have taken account of all the evidence. Individual messages cannot be viewed in isolation or out of context. The findings I make are those I am sure of. You, Scarlett, introduced the idea of killing people. At first, this was fantasy, but it developed into something real. By January 2023, you had a real desire to kill someone, which you shared with Eddie, asking him to help. You had a list of people you wanted to kill, mostly people you did not like. You did like Brianna, though. You were drawn to her. You thought she was different and interesting. You mentioned Brianna to Eddie and told him she was transgender. You talked of wanting to kill her. You tried to poison her by getting her to take ibuprofen tablets, which made her ill. You made a plan to kill a boy in Linear Park by slashing his throat and stabbing him, but he did not respond to messages, so you used that plan for Brianna. You knew she was vulnerable and needed friendship. You abused that. You were going to kill Brianna on the 28th of January, but her plans changed and she could not come. You made a new plan for the 11th of February, the day of the murder. Your motivation, Scarlett, was to act out your fantasies. The messages show you wanted to make a real victim feel pain and fear. When Brianna did not come on the 28th of January, you told Eddie that you wanted her to die really badly and that you wanted to see the pure horror on her face and hear her scream in pain. You suggested you wanted to keep some body parts, like a piece of flesh and an eyeball. 2 days before the murder, you said you were excited. Afterwards, you sent messages to people, drawing attention to the murder. You told Dr. Church you were excited during the murder and that you found it satisfying. Brianna's injuries show that she was killed with exceptional brutality, and the knife was used to inflict far more damage than needed to cause death. You, Eddie, did not show the same interest in killing as Scarlett did, or at least I cannot be sure you did. In some earlier messages, you tried to encourage Scarlett to think about other things, but as Scarlett's fantasies developed into real plans, you gave support and encouragement to her. The evidence shows that you were good friends and that you were able to question Scarlett and to say no to helping when it did not suit you. In some ways, Scarlett looked up to you. She saw you as cleverer than her. You saw her as someone who could help you socially, particularly talking to the girl you liked. You seem to have seen Scarlett's plans as a project. You were happy to help carry out the plans when you had nothing better to do. You were not involved in the first effort to kill Brianna by giving her tablets. But when Scarlett told you about that, you quickly offered suggestions about other ways to poison her. Scarlett was not the only friend you exchanged messages about death and killing with. You added details to Scarlett's plans, including the use of code words for when the attack was to start. The day before Brianna's murder, you asked Scarlett, "Have you asked it if it can go out tomorrow so we don't repeat last time?" suggesting you also wanted the plan to be carried through. It would, in my judgment, be wholly wrong to treat you as being under Scarlett's control. I also reject the idea that you only helped so Scarlett would help with your approaches to the girl. On the other hand, I acknowledge that you were not the driving force behind the plan to kill Brianna. Scarlett was. In your untruthful account to the police, repeated at trial, you suggested Scarlett's motive related to her boyfriend. This was part of your attempt to distance yourself from the killing altogether, something the jury rejected. I reject your evidence and instead look to the evidence in the messages written at the time when considering your motives. There is insufficient evidence to find that you, Eddie, were personally motivated by any sadistic desires. There is some evidence that you were upset after the killing, but you knew Scarlett enjoyed the thought of causing pain and fear. In some messaging, you even encouraged that, such as suggesting she could derive pleasure from watching someone die by hanging. You did not know Brianna. You knew only what Scarlett told you. She said Brianna was transgender and sent you pictures of her. Your messages about Brianna were transphobic. You consistently referred to her in a way that was dehumanizing, calling her it. You also described her as a femboy thing. When discussing killing Brianna, you agreed with Scarlett that she would be the easiest victim and said, "And I want to see if it will scream like a man or a girl." After the failed attempt on the 28th of January, and in answer to Scarlett expressing her desire to see Brianna suffering, you said, really all I wanted is to see what size dick it had. Because Scarlett is an unreliable witness, I will not use her evidence that you had a problem with gay and transgender people against you, nor will I dwell on the unpleasant messages about someone being gay and what you might do to them. But in your messages about Brianna, you undoubtedly displayed hostility towards her based on her transgender identity. Your explanation is that you were just copying language used by friends, including Scarlett, to fit in. Throughout the messaging, Scarlett almost always referred to Brianna as a girl and used the pronouns she and her, so you were not following Scarlett's lead. It may be that you picked up some of this language and the hostile views at school, but after considering all the evidence I have about you, I am satisfied that you are quite capable of holding your own views. I have now seen a great deal of expert evidence about you. For the record, I will upload to the digital case system a list of all the material I have considered. At an earlier stage in the proceedings, I had the advantage of hearing some evidence from Dr. Crawford, the psychiatrist at your unit, and from Dr. Bowers, a psychologist. I have also carefully considered the written evidence of Dr. Diggle. I have paid close attention to your presentation during the trial. You were helped to give evidence in an unusual way by typing your answers, because it was agreed you are selectively mute, not by choice. You coped well with giving evidence and were able to get across what you wanted to, including under cross-examination. Since you have been in custody, you have been diagnosed as having an autistic spectrum disorder at the mild end of the spectrum. You showed signs of autism from a young age, but you were able to attend mainstream school where you did well and were not considered vulnerable there. You had some friends, you had strengths and weaknesses, you liked to be seen as intelligent and had a real interest in science, but you were socially awkward. Your mutism is apparently a reaction to the situation you now find yourself in and the severe anxiety that has followed. At the time of the killing, you were living at home and well integrated at school. Looking at all the evidence, the expert reports, as well as the evidence at trial, I am satisfied that your diagnosis does not explain the way you referred to Brianna, although it does have some impact for sentencing. Using the table in Schedule 21 for young offenders, the starting point for those aged 15 or 16 at the date of offence is 20 years if the case falls into the category for which the adult starting point is 30 years. It is 17 years if the adult starting point would be 25 years. It is agreed by everyone that those are the two categories to consider. Paragraph 3 of the schedule explains that a case will fall in the higher category if the seriousness of the offence is particularly high. It gives examples of cases that will normally be included in that category. It does not say that they are the only examples of offences of particularly high seriousness, but this is a good guide to judges. Two examples are relevant here. They are a murder involving sadistic conduct and a murder that is aggravated by hostility related to transgender identity. If I do not treat you as falling into paragraph 3, then the 17-year starting point applies because the murder involved a knife being taken to the scene. That was part of the joint plan and so applies equally to Scarlett as it does to Eddie, whose knife it was. The starting point I use is just that. It is not the end point. I then have to weigh up all the things that make your offending worse, what we call aggravating factors, and all those that count in your favour, mitigating factors. Sadistic motives are not themselves enough to bring the case within paragraph 3. The test is sadistic conduct. Equally, the fact that there is some evidence of transphobia does not lead automatically to the higher starting point. Here it is agreed that the question is whether the murder was, at least in part, motivated by hostility to Brianna because she was transgender. My conclusions on these issues are important, but they are not decisive, because in the end, I am required to decide whether the offence is one of particularly high seriousness, and then to put everything else into the balance to reach the end point, which is what you will be most interested in. Scarlett, I have concluded that the primary motivation for Brianna's murder was your deep desire to kill. The messages reveal your fantasies and show your sadistic motives. Brianna's murder was exceptionally brutal. Your actions after the event and what you have told Dr. Church confirm you enjoyed the killing. Taking all that evidence together, this was a murder. The sadistic motives behind it, and you cannot avoid the consequences just by saying you did not have the same desires. I find also that you, Eddie, were motivated in part by hostility towards Brianna because she was transgender. You dehumanized Brianna by constantly referring to her as it, and your messages about wanting to see if she would scream like a man or a girl, and really wanting to see what size dick it had, along with checking the night before the killing that Brianna was coming, show your own interests in killing Brianna linked to your hostility towards her as a transgender person. Just as you knew of Scarlett's motives, she knew of yours. Although I cannot go so far as to say she used your transphobic attitudes to get you involved. I therefore find that you both took part in a brutal and planned murder which was sadistic in nature and where a secondary motive was hostility towards Brianna because of her transgender identity. In any event, however it is analysed, I think it is plain that this was a murder of particularly high seriousness, and that the part each of you played leads to the starting point of 20 years. Had I not reached that conclusion, I would have treated the sadistic motives and transphobic comments as significant aggravating features at the next stage. As it is, I will be careful not to double count things that have already gone into the starting point. There are many serious features in this case, but they overlap, and it would be wrong to treat each one as separately uplifting the minimum term. I also keep firmly in mind that you are very young, and you must be sentenced with the hope, if not the immediate expectation, that you can one day be rehabilitated, however cruel that may seem to those who have lost a loved one. Looking at aggravating factors, Brianna's murder involved a significant degree of planning and premeditation, with more general plans to kill other people. The planning started with you, Scarlett, and it was you who brought Eddie in. But Eddie, you joined in with the planning. I do bear in mind that apart from the awful subject matter, the plans were in some ways quite childish. Scarlett's notebooks were left where they could easily be found. But the extent of the planning, on any view, remains a significant aggravating factor for each of you. In your case, Scarlett, I have to bear in mind that you tried to kill Brianna by poisoning her. Although that does not apply to you, Eddie, you did encourage further attempts at poisoning, although that did not happen. Both of you were involved in the failed attempt to kill Brianna on the 28th of January and persisted when that did not come off. Brianna was vulnerable, as described by her family, even if not strictly to be treated as vulnerability in the statutory sense. You picked Brianna because you both thought she would be an easy target. In doing so, you, Scarlett, abused her trust. She thought you were her friend. You encouraged her not to be anxious and guided her through getting the bus. Eddie, you knew Scarlett was preying on Brianna in this way, and so it aggravates your offending too, although perhaps to a lesser degree than Scarlett's. I recognise these features are part of the planning I have described, and I avoid double counting, but they are still matters to put in the balance. I have taken account of the brutality of the killing and the use of the knife when assessing the starting point. I've also built in the sadistic motive and transphobic hostility. All these things are very serious features, but I have explained how they are linked, and so they do not each call for separate additional uplifts. They do, though, have to be recognised in balancing the aggravating and mitigating features. Taken together, they illustrate how serious this offence was, even in the context of other murders falling into the category I have identified. The attempts to conceal evidence were not sophisticated and do not have any significant impact. Brianna's body was not concealed, probably because you were disturbed. I will not speculate as to what might have happened if you had not been. It is an aggravating feature that you committed the murder in broad daylight in a park when there were other people around, including a family playing hide and seek and lots of dog walkers. It was always likely that other people would come upon the scene and suffer trauma, as happened. In considering mitigation, I have considered everything I have read about you, including the pre-sentence reports. I bear in mind your previous good character, although this must be viewed in the context of very serious offending and the contents of the messages. Within the 15 to 16 age range, there will be differing levels of maturity. I must look at your maturity while also thinking about any mental or developmental disorders which may have lowered your culpability, looking at the various reports on you both. Scarlett, the assessment of your intellectual ability fits with other evidence that you are not mature or clever. You have some vulnerabilities. Since you were about 14, you have had problems with your mood, anxiety, self-harming, and anorexia. Reports prepared before the trial suggested you had traits of autism and ADHD. Dr. Church no longer thinks that applies. You have changed your account since the trial. You have admitted taking part in Brianna's murder. You have said things about what you did and how you felt, both to Dr. Church and to others, including Miss Howarth, who wrote the pre-sentence report. You have lied so many times, Scarlett, that it is impossible to know what is true and what is not. There are, though, worrying things in the recent reports. You have expressed the desire to kill again. If those thoughts continue, you will not be released. Dr. Church's latest report will need to be retained on your file. It contains important information the parole board would need to consider. You have shown no remorse. Having now assessed you several times, Dr. Church has diagnosed that you have a severe form of conduct dissocial disorder, one of the features of which is having no empathy. Your lack of empathy does provide some explanation for how you could commit such a dreadful murder, but in my view, it does not significantly lower your culpability. There is no suggestion that you did not know that what you were doing was wrong or that you were unable to control your actions. You were able to plan in an organised way and had full awareness that it was criminal behaviour. In short, your diagnosed disorder did not drive your actions, although it meant you did not have the mental break that most people have to stop them wanting to harm others because that feels wrong. It may not have felt wrong, but there is no doubt you knew it was wrong to act as you did, and you chose to do so anyway. I take account of the diagnosis, but in my view, it offers limited mitigation. There are no other relevant diagnoses in your case, but there are some concerns about your mental health and how you will respond after today, which those responsible for your care will no doubt note. Scarlett, it is clear that if you are ever to be released, a huge amount of work will need to be done with you first. But the hope remains that this can happen, and you should work hard on your rehabilitation. Eddie, you have been described as extremely vulnerable. There are areas in which your functioning is like that of a much younger child. Your social skills are certainly not as developed as most people of your age. I have looked carefully at the limitations outlined by Dr. Diggle, but it is hard to view these limitations as significantly lowering your culpability for Brianna's murder. I should also say that my analysis of your offending differs in some important respects from that contained in the pre-sentence report. Ms. Howarth has attempted to make sense of what you have told her, but you have not given a truthful account. I have found her report helpful, though, reading it in the context of my factual findings. I bear in mind that it is difficult for a proper assessment to be made as to the impact of your ASD while you continue to deny what you did. But I am confident from all I have seen that you knew very well that what you were doing was terribly wrong and that you were capable of saying no to Scarlett. Your autism cannot provide any real excuse for the offence. I do, though, recognise that some downwards adjustment is required in balancing against the aggravating factors to reflect that you are less mature than many others within the 15 to 16 age category, and that your thinking skills are less developed in several areas. More generally, your ASD, severe anxiety, and selective mutism has made your experience of custody more difficult. Despite this, Dr. Crawford's latest report shows reasonable progress. You have managed to pass your GCSEs while in custody and to begin studying A-levels, and you have agreed to start speech and language therapy. Although you showed no remorse at trial, or indeed today, the pre-sentence report showed some insight into Brianna's family's feelings. You told Miss Howarth, I wouldn't think that there is anything to say because I'm certain that there is nothing either of us could say that would ever help them with their situation and would more than likely cause more pain. This is, in fact, quite a mature statement and one that may be built upon. I also find that it is consistent with my view that despite the limitations identified in the expert evidence, you are capable of thinking about the consequences of your actions. Taking the evidence as a whole, I find that the impact of your ASD on your culpability is limited. I do not doubt that transferring to prison when you are an adult will be difficult. Prison is more difficult for those who are neurodiverse. Your behaviour in custody has been good so far, and it is clear from the pre-sentence report that there is a hope that you may one day be rehabilitated. You must continue to work towards that. I have weighed all the aggravating and mitigating factors that apply to each of you. Although I have taken the same starting point, I have concluded that the final minimum terms must be different. In Scarlett's case, the aggravation features are significant and would have led to a substantial uplift to the starting point, but for the mitigation, particularly that relating to maturity and mental disorder. There must still be an uplift, but it will be moderated. In Eddie's case, I find that the balance to be struck between aggravating factors, which are not quite as high as in Scarlett's case, and the mitigation I have identified is such as to cancel each other out. In saying that, I have taken account of all the medical evidence and accept the diagnosis of ASD has some impact, but the extent to which it reduced your culpability in the circumstances of this offending is limited. This was undoubtedly a very serious offence with multiple aggravating factors. That is the context in which I impose minimum terms which are lengthy for offenders of your age, albeit significantly less than an equivalent sentence for an adult. The parole board will have to decide if and when either or both of you can be released. That will only happen if you no longer pose a danger. If you are released, you will remain on licence for life and you may be recalled to prison. I will now sentence each of you. You may remain seated. In both cases, the relevant statutory surcharge will apply. Scarlett Jenkinson, for the murder of Brianna Jai, you will be detained at His Majesty's pleasure. I set the minimum term at 22 years, less the 352 days that you have spent on remand. Eddie Ratcliffe, for the murder of Brianna Jai, you will be detained at His Majesty's pleasure. I set the minimum term at 20 years, less the 352 days that you have spent on remand. Please take the defendants to the cells and their legal teams will come and see them before they go to begin their sentences. Thank you.
All right, so that was the sentencing of Scarlett and Eddie. Now we are going to be watching the appeal of the sentencing of Eddie. So Eddie has gone back to the UK court saying that is not happy. Appeal is decision, their decision. So we're gonna just be watching that now. Hopefully the internet will stay as okay for now. If not, just remain on here because the stream will go on. But I'm just again having an issue with my internet provider. I have to reboot the modem, but it should be fine in a couple of minutes. So just hang tight, but should be fine for now. But yeah, so let's just watch. The sound might not be very good because it's UK courts. They are not still prepared, not even the US are prepared for court streaming. But here we go. I mean, by the title you probably already can see what happened, but it's gonna be interesting. Let's hear it.
In the Court of Appeal Criminal Division on the King against Eddie Ratcliffe.
Thank you, Mr. Littler. There are no reporting restrictions preventing identification either of Scarlett Jenkinson or Eddie Ratcliffe, but there are reporting restrictions relating to any of the children that may be mentioned in the case, with the exception of Scarlett's boyfriend, who may be referred to as O.
Thank you.
Thank you.
Well, can I start by introducing the parties?
Please.
I represent the applicant, Eddie Ratcliffe. My junior is Mr. Swift, and the Crown today are represented by Miss Here, King's Counsel, and Miss Mottram of Counsel.
Yes, thank you.
And as my lady knows, this is an application for leave to appeal a sentence.
Yes.
A sentence which was imposed on the 2nd of February of this year when Eddie Ratcliffe was 16 years of age.
He's now 17 by my calculations.
He's now 17, yes.
Yes.
And he received a detention at His Majesty's pleasure and a minimum term of 20 years imprisonment minus the days served. His co-defendant, Scarlett Jenkinson, also 16 at the time, was sentenced to a minimum term of 22 years minus the days served.
Yes.
We've had an opportunity to speak or liaise with Eddie Ratcliffe this morning on the link. He is accompanied by his solicitor, Mr. Rawson, and we intend to place before the court as simply and succinctly as possible our submissions on behalf of the applicant.
Yes, I'm sure you will have informed Mr. Ratcliffe and relatives and all those involved in this matter that we are given the papers in good time advance of the hearing. And that allows us to read all the material, including the medical reports, very carefully before we come in to hear the arguments. And we also have received your barrister's written arguments, Mr. Ratcliffe. And so we understand the outline and most of the detail of the submissions before us. But Mr. Littler, you will take your own course, but just to make that clear to everybody, so that is why you don't need to go through the full detail, in particular, I think, of all the medical evidence.
Precisely. And what we intend to do is to, in short form, I hope, place before the court the main arguments towards this appeal, and also now take into account the submissions made in the respondent's notice from the Crown.
Yes, of course.
It's conceded in this case, and the starting point is it's conceded in this case that a starting point of 17 years was appropriate because this was a murder which involved the bringing of a weapon to the scene.
Yes.
However, that concession...
Well, the bringing of a knife.
Yes. But you would fall within that category with it being a weapon or knife. But in this case, my lady's right, it was a knife. That concession was on the basis that the applicant shared, however, the same maturity as most 15 or 16-year-old boys. And we submit, it is clear from the sentencing remarks that her ladyship came to the conclusion that he did not. And as the court is familiar, when considering a child or a young person, their age, their emotional and developmental age is at least of equal importance to the chronological age. The court is aware of the sentencing guidelines for children and young persons, the case of SK, and I know my lady is familiar with the case of Kamara Jarrah, in which case it was stated that it is never just a question of mathematical age. Age governs the normal starting point for the minimum term, but not the assessment of culpability by reference to maturity. And it's really culpability and maturity which are at the heart of this application. And the court will also be familiar with the case of SK, where it was stated quite clearly that when assessing culpability, the sentencing judge should reflect on and make allowances as appropriate upwards and downwards for the level of the offender's maturity. Now, it is right to say that we submit an analysis of this applicant's maturity. He is closer to the starting point of a 14-year-old rather than a 17-year-old boy when considering the table within the Schedule 21. And the court know that looking at Schedule 21, if this is a case where a weapon or knife is brought to the scene and we are dealing with a 15 or 16-year-old, the starting point ordinarily would be 17 years. If the age is just 1 year below, 14 years, the starting point is 13 years, a rather large step down from 17 to 13. And so the point we make is that age, maturity were very important issues in this case and could very much affect the end result for this particular applicant. Now, rather than inviting this court to carry out the task of a jury, I'm certainly not going to do that, and go on a fact-finding mission, I'm not going to do that either. I'm simply going to invite the court to apply the findings which Her Ladyship found. And within the sentencing remarks,
Yes, let's look at those.
Yes.
Mm-hmm.
Within the sentencing remarks, Her Ladyship at page 12,
yes.
paragraph G,
yes.
said Eddie was assessed by all experts as vulnerable. That was not in question. She confirmed, Her Ladyship confirmed, there are areas in which your functioning is like that
just to be accurate, what she said was, Eddie, you have been described as extremely vulnerable. Yes.
At 12G, the same paragraph, there are areas in which your functioning is like that of a much younger child. Her Ladyship is referring to the report of Dr. Diggle.
Mm-hmm.
She does not question the report. The Crown did not question the report. No other expert questioned the expert opinion of Dr. Diggle.
Mm-hmm.
At paragraph 12G, the same paragraph, your social skills are certainly not as developed as most people of your age. And then Her Ladyship says this, I have looked carefully at the limitations outlined by Dr. Diggle, so they were considered, but it is hard to view these limitations as significantly lowering your culpability for Brianna's murder, paragraph 12G. So Her Ladyship is not questioning Dr. Diggle's conclusions, and I assume that is why there was no requirement for Dr. Diggle to come to court to give evidence. It was just that Her Ladyship did not believe the conclusions within the report, which are correct and not disputed, whether they applied to this particular case. Now, Dr. Diggle's assessment of Eddie Ratcliffe confirms that he was autistic.
At what, there's always a range here. Lower end, was that his conclusion?
Would your Ladyship just mind my back?
Was autistic spectrum disorder, but not core autism, as he called it. Then it's Dr. Crawford who says mild ASD.
Yes. Probably more importantly, when looking at culpability, is the effect the autism has on the individual, because we're told from the sentencing guidelines to look at this on a very individualistic approach.
Yes.
So looking at the individual and Dr. Diggle's assessment of Eddie, which followed a long assessment of Eddie by Dr. Diggle. And as I repeat, no other expert qualified or criticised the conclusions that were reached. The conclusions of Dr. Diggle were that Eddie's functioning was more like that of a much younger child, in brackets perhaps 7 or 8 years old. But more importantly, the report specifically said this, that Eddie had a lower than expected ability to express what he thinks or articulate his ideas. He was inclined to exhibit naivety, be less mature, and have a greater difficulty understanding the fine meaning of things and contextual information. The court is therefore approaching sentence in respect of a young teenage boy who has been assessed as someone with a low age potential, poor social skills, naivety, immaturity, and an autistic diagnosis by professionals.
All of these were matters that the judge, do you agree, undoubtedly took into account as relevant to mitigation?
There is no doubt they were taken into account, but they were not taken into account fully. They weren't taken into account specifically when addressing the examples of offences within Schedule 21, which may trigger in this case. For example, they weren't taken into account when assessing whether Eddie Ratcliffe was motivated because of hostility. The evidence to support that came from text messages, came from social interaction with Scarlett. So it wasn't taken into account sufficiently towards that, and I'll address that later, but it also wasn't taken into account sufficiently regarding the starting point.
She did deal head on, moving on from the passages you've helpfully taken us to, top of page 13, to explain exactly why she did not consider these issues really lowered culpability, didn't she?
She did.
And she said this, it's difficult for a proper assessment to be made as to the impact of your ASD whilst you continue to deny what you did, which was, and as I understand it, remains Mr. Ratcliffe's position. She says, and made the finding, confident from all that she had seen, that Mr. Ratcliffe knew very well that what he was doing was terribly wrong and that he was capable of saying no to Scarlett. And that was the foundation of her conclusion, that the autism could not provide any real excuse for the offence, though it was obviously relevant to mitigation, as you put it.
Yes.
You don't criticise, at an appellate level, is it open to you to criticise that assessment in that paragraph?
The assessment was really focused on whether it played a part in the offence, and it clearly didn't play a part in the offence, and that's why the autism and the expert evidence was not deployed at trial, because the issues are very different at trial. The issues here are culpability,
yes.
And so they are relevant, very relevant to the lead up to the offence. They are very relevant to...
So no criticism of the approach to culpability by reference to Dr. Diggle's report. Your point, as I understand it, is that it was relevant to motivation findings. And is that a fair summary or not?
I don't believe that Dr. Diggle's report was applied as it should be fully by her ladyship generally.
And in that you include culpability, do you?
Yes.
So what is wrong with the paragraph that I read out to you in terms of the judge's assessment as to the impact of the ASD on culpability?
Well, the assessment that she reaches or makes is based really on what evidence?
Well,
the conclusion seems to be that having heard your evidence and looked at the facts of this case and the murder itself, her ladyship came to the conclusion she didn't believe that autism played a part. But I think that was a sweeping generalisation.
what she said was, you knew very well that what you were doing was terribly wrong. You were capable of saying no. And not that autism didn't play necessarily any part, but could not provide any real excuse for the offending.
Or the offence.
Correct.
Yes. And
what's wrong with that?
Well,
for today's purposes.
Nothing is wrong in principle with what is said there, but clearly from the sentence imposed, insufficient weight was given. And as I stated earlier, I think her ladyship uses it's no excuse for the offence. The point I make is that autism and culpability and social skills and naivety and immaturity, they are relevant to the planning towards and the days leading up to and the messages about transgender.
As I said, that she undoubtedly recognised that these were matters, the autism and immaturity were obviously matters that came into the mitigation exercise.
Yes, absolutely.
Separate to culpability.
And also quite clear in the sentencing remarks, concludes that they were of limited value.
Yeah.
Which is, I submit, a wrong conclusion, given the expert evidence unchallenged before the court.
Which conclusion do you say is wrong in the sentencing remarks?
It gave limited assistance when considering culpability. That was the conclusion that was reached by her ladyship in relation to
yes.
the autism and the matters I've addressed with the court. And that conclusion that it was limited was not an accurate conclusion given the expert evidence before the court.
Well, sorry, the sentence I was referring to in the transcript says she recognizes that some downwards adjustment is necessary.
Yes.
And really your dispute is simply that, she didn't go far enough.
Absolutely.
It's a question of degree, but she does recognize the principle.
Oh, she does recognize the principle.
And she was a trial judge, had heard all the evidence at the trial.
She recognizes the principle, and she was a trial judge, and there has been a downward adjustment, but looking at the end figure and the conclusion that it was limited, and the observation that it doesn't really assist when looking at the offence, not enough weight was attached to his condition when considering the transgender's message,ing
okay, well, that
how
goes
he
back to the
became
first point. That's the pre-offence
yes
stage, and I understand your submission there. But on culpability, I think you said all you can.
Yes.
In this context, and we've looked at the two passages that are directly relevant on the issue.
Yes. Could I look then? The submission we make is that the sentencing exercise was arguably made more complicated than it needed to be, because there was a need, it would appear, to try and place Eddie Ratcliffe's sentence within one of the examples of Schedule 21. And we know that you don't need to fall within one of the examples in Schedule 21 if a case is particularly high seriousness.
That's right, the judge recognises that expressly in her sentencing remarks.
She does. However, the judge we suggest was wrong in dealing with sadism. We submit that helping or encouraging Brianna to commit a sadistic murder would be an aggravating feature, giving rise to an uplift to the appropriate starting point. If one considers the sentencing remarks, her ladyship makes it clear she didn't find Eddie Ratcliffe conducted himself in a sadistic way during the murder. And indeed, there was no finding that the killing involved sadistic motivation from Eddie. Indeed, it's page 7C, her ladyship agreed there was evidence that Eddie was, in fact, upset after the killing. And her ladyship also
What was that evidence? Because I struggled to find it.
It was, I think
there was a concern that he might be caught.
It was the text message. It was a mixture of two things. It was him walking away, and he had his head down, and it was his demeanor on CCTV going home. But in the main, it was the messages going between him and Scarlett when they were talking about being caught. And
can you, if there is a reference, please, to showing upset for Brianna after the killing, or distress that you say is relevant, then it would be very helpful to have that, please. Thank you.
As I say, her ladyship at 7C concluded there was evidence that Eddie was upset after the killing. We'll look for that. Her ladyship also agreed that Eddie did not show the same interest in killing as Scarlett, and she highlighted at page 6D earlier messages when Eddie tried to change the subject or talk about other things when they were talking about what they were going to do to the different people. There were quite bizarre messages which we would say are classic autism, where he is effectively, on the one hand, discussing with her what they might do the next day to Brianna.
I mean, you're absolutely right. And this is coming from the judge herself, setting out all the positive things.
Yes.
And very carefully, it might be said, for example, you took us to 7D or C, insufficient evidence to find that you were personally motivated by any sadistic desires, some evidence of upset after the killing. But, she goes on, you knew that Scarlett enjoyed the thought of causing pain and fear, and in some messaging you even encouraged that, she said, such as suggesting she could derive pleasure from watching someone die by hanging.
Yes.
So is it fair to say that the judge succinctly, but does always put both sides of the coin there?
Yes, and the reason why I'm reminding the court of this is that she clearly drew a distinction, quite a stark distinction, between the two. Because her ladyship went on to talk about the sadistically motivated killing by Scarlett and came to the conclusion that she was a fantasist. Page 9, paragraph E, a deep desire to kill. It's quite clear from the post-trial report prepared by Dr. Church that she bragged about the killing, and there's no doubt that Dr. Church, at the end of his report for her, he recognized that she posed a high risk of extreme violence going forward, and she would need monitoring going forwards. Even though Eddie is not seen as a sadistic killer, even though his motivations were different and arguably less culpable to Scarlett's, her ladyship went on to say that he could not, however, avoid the consequences of assisting someone to do that. And that must be right. It must follow that if somebody assists somebody else who has a sadistic desire or wishes to carry out a sadistic murder, that will be an aggravating feature for the person doing the encouragement and assisting. But her ladyship has brought Eddie in here to the determination under Schedule 21 regarding a sadistic murder or one motivated by such. And it's not clear from the sentencing remarks whether her ladyship found Eddie to be at a 20 starting point for simply encouraging or assisting a sadist. And we make this very simple point, and in fairness to her ladyship, she was doing just that. She was drawing a distinction between the two. On the one hand, you have a very dangerous defendant, and on the other hand, you have another defendant who does not have the same sadistic motives. And again, whilst we concede that might have been an aggravating feature, certainly not something which would place him within one of the examples of Schedule 21 and give him a starting point of 20 years. Again, his maturity, his autism has to be fed into how he encouraged, why he was motivated to encourage and assist. Her ladyship didn't clarify to what extent the motivated by Brianna being transgender impacted. From my reading of the sentencing remarks, it appears that her ladyship has concluded that it's a combination of Eddie Ratcliffe assisting someone who intended to carry out a sadistic murder. She's combined that with Eddie Ratcliffe showing some signs of a motivation of violence towards someone who is transgender. And it's a mixture of the two which has led her ladyship to a 20-year starting point. And it's not made clear which one of those two things. Was it the encouraging a sadistic murder, or was it having beliefs?
It's not binary, is it? They're not mutually exclusive.
They're not.
She says in terms, I therefore find that you both took part in a brutal and planned murder which was sadistic in nature, and where a secondary motive was hostility towards Brianna because of her transgender identity. However it is analysed, I think it is plain this was a murder of particularly high seriousness. That's the point. And as you've very helpfully identified, there are many ways, different ways of reaching that threshold. Here, as it happens, there were two of the particular examples given in Schedule 21 in the judge's assessment that were engaged to greater or lesser extents.
I totally agree, my lady. The difficulty and the danger always is, though, that sometimes Schedule 21, the list of offences, can be very helpful in a clear-cut case. When it's not a clear-cut case and sentencing judges dip into one offence and dip into another and bring them together to bring around 20 years, that's when it starts to get confusing. That's when it lacks clarity. And it isn't clear from the sentence to what extent these two aggravating features, and we agree they're aggravating features, it's not clear to what extent they played a part in moving this case to 20 years. Because our submission for the sadistic motive was there is a massive difference between a sadistic killer being sentenced with all that risk upon release and somebody assisting and encouraging a sadistic killer in a murder. One is more secondary than the other. One will receive a lesser sentence than the other. And in the same way with the motivation born out of discrimination, in fairness to Eddie Ratcliffe and the evidence, it is quite clear from the sequence of events document and the evidence before the court that the real motive for Eddie Ratcliffe to assist was simply to assist Scarlett. For whatever reason, her ladyship rejected the idea that he was doing it in order to become closer to a girl that he liked. But for whatever...
He obviously gave no evidence about motive because he denied any involvement. Is that right?
Yes.
To the police, he said it was Scarlett and she was doing it because of her boyfriend.
Yes.
And the judge said that was she didn't say, but it's at least arguably quite a sophisticated way of trying to push the blame onto Scarlett away from himself?
Just working on the basis that Eddie's explanations as to why he got involved are not correct. The reality is that for whatever reason, Eddie was motivated to assist Scarlett, and the conclusion of the judge was that that was not through a sadistic motivation. But the Scarlett kill lists, as they were called during the trial, were not gender specific at all. They were people that she disliked. And there were many potential victims on Scarlett's list, most of them, ironically, boys who she was upset with. In fact, the evidence alarmingly was that on the day in question, their intended target was someone else altogether, but that person wasn't available. I said quite candidly at the sentence hearing, when I was trying to persuade Her Ladyship that this was not killing born out of hatred towards a particular gender, I said on that hearing, what I'm actually saying is arguably worse. He was clearly that day prepared to kill whatever the gender. But on the evidence, it was wrong, we submit, to say that he was motivated for this reason. That motivation came from the text messages and the messaging between him and Scarlett.
I understand you can say wrong, but obviously in this court, the test is different.
Yes.
Are you saying it was a perverse conclusion, such as to justify interference by us?
It was a conclusion which did not justify a consideration of the starting point within Schedule 21.
So you don't challenge the conclusion, you challenge the extrapolation from that conclusion that the starting point should be 20.
I challenged that the weight attached to it was far great, as with the sadism. The weight attached to it was far great, but I concede that if there is evidence, and there was, of messages which were deeply offensive, which in some way attempted to describe the intended victim, then that would be
Brianna specific.
That would be a aggravating feature. But again, and this is why mental health and maturity really flow through this case. If you have a boy who is more like an 8 or 9-year-old, but let's say for argument's sake, a 14-year-old who is sending deeply offensive messages, the same boy who is less mature and lacks those social skills as found by Her Ladyship, how do those messages sent translate into sure evidence upon which we can categorize Eddie Ratcliffe within Schedule 21 and bring about a starting point of 20 years? We submit that it's clearly an aggravating feature, but it's a modest aggravating feature, given the messages which were sent, and also given the autism and the immaturity. I suppose what we're submitting, putting it as simply as possible, is if one stands back from this case and looks at all of the aggravating features and all of the mitigating features, and if one for one moment just ignores Schedule 21 and go back to what we did before, if we can put it that way. Let's imagine Her Ladyship started with a starting point of 17 years at the beginning, because this was a weapon or knife being brought to the scene. Again, applying Her Ladyship's conclusions on the important aggravating and mitigating features for both this applicant and Scarlett. Firstly, it was concluded that Scarlett introduced the idea of killing. She had the list, she fantasized, she had the sadistic motive. It was agreed Eddie did not, but assisted. So immediately there is a difference, we submit, with that aggravating feature.
Just pausing there, just for the, by way of confirmation, you expressly eschew any argument based on disparity. That's what we have taken from paragraph 35 of your advice and grounds of appeal.
I don't argue parity, but I do say the sentences which were imposed clearly show, however, that the end point that Eddie reached with the aggravating features was far too high. And when you compare the two sentences,
well, that is a disparity argument.
Well, we do argue that it's clear when one looks at the 2-year differential between the two that it must be the case that Her Ladyship has not taken into account the difference in the aggravating features and not taken into account the mitigation which was available to Eddie but not to her. And that's why I approach it in this way. If we were starting at 17 for both, we know straight away that they are on a very different level when it comes to their idea for the killing, the fantasy, and the sadistic nature. We know that Eddie, according to Her Ladyship, however, has the aggravating feature that Scarlett does not have, which is the offensive language. But again, we argue that those messages need to be looked through the prism of a young boy with a immaturity, naivety, and an autistic diagnosis. But, my lady, the next point we make is this. It's clear that both of them went down to Linear Park twice. The first time it was aborted. Aggravating feature for both. But Scarlett actually tried to kill Brianna by poisoning her.
Okay.
And admitted it.
I am struggling, and it may be my fault. Is this a disparity argument or not?
It is to this extent.
What are you asking us to conclude?
I'm asking you to conclude that to have a sentence which results in 2-year differential between these two defendants demonstrates that Her Ladyship has given a far too high starting point for Eddie Ratcliffe, wrongly applied Schedule 21, and not taken into account the mitigation and in particular the medical evidence regarding his immaturity and his autism. And for Eddie Ratcliffe to only receive 2 years less than Scarlett, when Scarlett admitted having tried to kill Brianna by poisoning her days before, speaks for itself. It's also quite clear, not only that one was sadistic, one was not, one had tried to kill before, one didn't. It's also clear that the planning from both of them was different. Her Ladyship, within her sentencing remarks at 7B, says that both planned towards the murder, but Eddie was not the driving force behind the plan. And therefore, with that aggravating feature, more of an uplift for Scarlett, less of an uplift for Eddie. I introduced, not the Crown, in my skeleton argument, I introduced abuse of trust as an aggravating feature in this case, and it was deployed correctly by Her Ladyship. Scarlett abused the trust of Brianna. But it's right that Eddie Ratcliffe assisted Brianna when she breached that trust. But there's no doubt that Brianna was her friend. Scarlett chose the location, the time, the weapon, and directed her movements to the park, even telling Brianna in a text, don't get a return ticket when you get the train or bus. Eddie had never met her. So there's an abuse of trust, but it's different for both of them In the pre-sentence report and within the sentencing remarks, Her Ladyship very fairly concludes that at least Eddie showed some remorse, and that's echoed in the pre-sentence report. You could not get further away from any remorse for Scarlett, who at one stage asked Dr. Church, the expert preparing her report, whether she could include something in her report to assist her with sentence. She showed no remorse at all.
Interestingly, 13D, the passage you're referring to, the judge says this to Mr. Ratcliffe: although you showed no remorse at trial, or indeed today, the pre-sentence report showed some insight into Brianna's family feelings. He said, I wouldn't think there is anything to say because I'm certain that there is nothing either of us could say that would ever help them with their situation and would more than likely cause more pain. That is the extent of the remorse you're referring to.
Yes.
She goes on, this is in fact quite a mature statement and one that may be built upon. I also find, she says, that it is consistent with my view that despite the limitations identified in the expert evidence, you are capable of thinking about the consequences of your actions. Do you take any issue with that analysis?
That is certainly one conclusion that could be reached from the trial judge, but the trial judge is not an expert in autism. And the trial judge did not invite any oral evidence from an expert in autism, and no expert in this case has ever qualified or criticised the conclusion reached by Dr. Diggle. Now, whether this court finds more weight in a full assessment by a qualified expert who assesses Eddie as being autistic, aged between 7 and 8, with all of those difficulties, but prefers the assessment of a trial judge who reads a pre-sentence report and one response in it.
But Mr. Littler, Dr. Diggle did not say anything inconsistent with the judge's conclusion that he was capable of understanding the consequence of his actions. The high point of Dr. Diggle's evidence at paragraph 23 is that he has a lower than expected ability to do various things. There's no suggestion, is there? And if I'm wrong, please tell me. No suggestion whatsoever that the applicant, Mr. Ratcliffe, is incapable of understanding the consequences of his actions, was not capable at the time of understanding the consequences of his actions.
There's no suggestion, and that wasn't something that Dr. Diggle disagreed with. But as the court know, cases come before this court regularly now, and we're regularly told that maturity of the applicant or appellant is now central. And what Dr. Diggle did say is that he was naive, immature, difficult social skills, and so on. And those are all relevant issues today. And so the point that I make is that the aggravating features that I've just gone through, if we were to start at 17 years, those aggravating features were more for Scarlett, far more, including a previous attempt to kill her, than for Eddie. And then all of those differences between the two with regards to aggravating features, and some of them were enormous aggravating features for Scarlett, then we look at the most important thing in this case, which is the maturity, the naivety, the autism, and we consider culpability. And that did not apply to Scarlett, because the only conclusion reached by Dr. Church was that, having heard from Scarlett when he made his report for the court, he U-turned effectively, Dr. Church, and said, I no longer believe that she has autism or ADHD. The only finding that Dr. Church made of Scarlett was that she posed a risk for the future. So there was no mitigation, in truth, for Scarlett with regard to her mental health, and there was no suggestion of immaturity.
Forgive me, page 11 of the sentencing remarks, Scarlett, says the judge, the assessment of your intellectual ability, I mean, she was clearly not as clever as Mr. Ratcliffe on the evidence that was being looked at here. the judge says, Scarlett, you are not mature. So she was not treated as being mature or clever, in contrast to Mr. Ratcliffe. You have some vulnerabilities, said the judge. Since you were about 14, you have had problems with your mood, anxiety, self-harming and anorexia. So it's not entirely fair to say, there are the difficulties of disparity arguments, isn't it? That Scarlett didn't have her own troubles.
It is fair to say that for trial purposes, when Eddie Ratcliffe, I do apologise, when Eddie Ratcliffe was before the court, he basically, his defence was always going to be that he was autistic. And before the trial, the line taken by the Scarlett Jenkinson team was that she was also autistic.
Mm-hmm.
And that was obviously problematic for our team because the jury then had two defendants with an identical condition. What became clear after before the sentence was that Dr. Church came to the conclusion that that had been effectively an invention by her, because obviously with autism and ADHD, that diagnosis. I
don't want to distract you, but you were making the submission that Scarlett had no issues, and by contrast, Mr. Ratcliffe did. And I was suggesting to you that actually there was an assessment that Scarlett was also not mature, she wasn't clever, and she also had vulnerabilities. So that's the short point I was making.
Well, that's correct, but I mean this is the point we make is that they were on totally different levels. I mean, you could see that just by the way they gave their evidence. On the one hand, we have one defendant who has got an autistic condition, who did have special needs at the trial, who is being assessed by an expert as being naive and immature, with poor social skills, and
all right, I think
with a Scarlett, that wasn't the case.
Okay. Yes.
So our submissions are that the applicant's sentence was wrongly and artificially elevated to 20 years, applying the example offences within Schedule 21 wrongly. It's unclear how the starting point of 20 years is reached. Maybe a combination of sadistic murder, encouragement, and hostility towards transgender people. If the court had started at 17 years and ignored Schedule 21 and applied simply the aggravating and mitigating features and applied the maturity test and considered his autism, the sentence would have been below that of 20 years. And the gap between Scarlett's sentence and Eddie's sentence evidences the fact that the starting points were too high for Eddie. Insufficient account was given to the good medical mitigation in his case. Well, those are my submissions.
They've been very clear. Thank you. Any questions, Nick? Any questions, Ed? Thank you very much, Mr. Littler. Mr. Swift, do you follow in any way?
But Melanie, there was just one matter that was raised in respect, I think it was page 7C,
yes.
As to evidence that Eddie had been upset after the killing. Looking at the sequence of events, there are some messages. I can give page numbers if,
please.
If required. Of the sequence of events, it's at page 243 with reference to, I don't know whether that's the easier reference, there are a series of messages there. That's on the 11th of February. I would anticipate her ladyship was referring to messages and indeed searches that Eddie was conducting in respect of meditation for anxiety, coping with tragedy and tragic events. That's at line 107. And it moves on to messages that are sent to Scarlett with reference to Scarlett suggesting this may be a time to approach the other female that Eddie had shown interest in. So I'd anticipate it was those messages, and they follow in similar vein in the next couple of days with searches for anxiety-related websites.
Thank you.
In contrast, perhaps, to the way in which Scarlett was behaving at the time.
Thank you. That's very helpful, Mr. Swift. From recollection, the anxiety that Mr. Ratcliffe had expressed was for his whether or not he was going to be caught. We can't. Is that? Am I right in remembering that?
Their searches of websites in relation to that. There's no clear expression as to why he's doing that, but it follows. Yes.
No, there was a clear expression. There was a clear expression by him in discussion with Scarlett. Let me just give me a moment.
I think that may be page 251.
Thank you. Yes, do you have anxiety about being caught? Says Scarlett to Eddie. Probably, says Mr. Ratcliffe.
My lady, yes.
And that is at same evening around 11 o'clock at night. And these searches are before 5:30 in the afternoon. So just to give you the opportunity to comment.
But lady, yes, perhaps their representative, I appreciate it's trying to step into the mind of Eddie at the time. Perhaps that they highlight his anxiety and turmoil following the killing, in contrast to the actions and attitude of Scarlett. Beyond that,
Right.
I can't take the call.
No, well, you've done. Thank you very much. It's very helpful. Anything else? No. Thank you very much, Mr. Swift. Yes, Ms. Here.
My lady, the single question, of course, that the court has to answer is whether the sentence imposed on Eddie Ratcliffe was manifestly excessive. It's clear in my submission that the learned judge took into account all the relevant aggravating and mitigating features in order to reach the end point of a 20-year minimum term, less time served on remand. Now, this is an application for leave to appeal against sentence. So I'm in the court's hands as to how you want me to proceed.
I think make your submission substantively in a rolled up fashion, I think would be the best way of going forward.
Can I then deal with the starting point of 20 years first of all? It's my submission that the 20-year starting point, and I'm going to use that as shorthand, it's 20 years starting point for a 15 to 16-year-old. But the 20-year starting point was the appropriate starting point on the evidence in this case. And the question of whether it was the appropriate starting point was a matter for the learned judge to determine, bearing in mind that this was a contested trial on the evidence that she had heard. Forgive me. Was that?
Yeah, thank you very much.
Now, she made two findings that brought it within that sentencing category. The first, that it was a murder involving sadistic conduct, and the second, that in respect of Eddie, it was a murder motivated in part by hostility towards the deceased based on her transgender identity.
It's important to remember that Section 66 of the Sentencing Act addresses what is meant by motivation by hostility and makes it clear that partial motivation brings it within the definition.
Absolutely. There were, and I've set this out in the respondent's notice, there were, in fact, two other routes that the court could have taken to that 20-year starting point, which were not drawn to the learned judge's attention through my oversight. And I must apologise to the court and to the learned judge for that. But in fact, paragraph 3, subsection 2I, brings into play features identified in paragraph 2 of Schedule 21. In this case, of course, Brianna was a child. definition of a child being under the age of 18 years, and therefore the court could have reached a 20-year starting point by finding that this was a murder of a child involving sadistic motivation rather than sadistic conduct. But perhaps a more straightforward route would have been that it was the murder of a child involving a substantial degree of planning and premeditation. Now, as it was, the judge made no findings about those two features of paragraph 2 because I didn't draw them to her attention. But it would be my submission that she made findings on the component parts of paragraph 2, which would effectively allow this court to conclude that they would have led to the same destination.
Well, obviously, this is a point that's been flagged up with Mr. Littler.
It's in the respondent's notice.
Yes. Okay. Well, we'll give him the opportunity to comment on this.
Yes.
But your point is, and it may not make a difference at the end of the day, but this would have been a murder falling within paragraph 2.2.
In any event.
Being what? A murder of a child involving a substantial degree of premeditation or planning.
Yes.
That's your submission.
Yes. But recognizing that that wasn't the way that the prosecution put it in the court below, can I deal with the findings that the learned judge did make?
Yes.
Because it is my submission in any event that she was entitled to reach the conclusions that she did on the evidence that she heard. So dealing first of all...
Just one moment, please, Ms. Dear.
Yes, so these were two findings that the judge was entitled to make on the evidence. I've referred in the respondent's notice to the well-known case of King. My lady will be more than familiar with the principle, which is that this court should not interfere with her findings of fact unless they are findings of fact that no properly directed jury could have reached on the evidence. And that, in my submission, is plainly not the case here. I've referred in the respondent's notice, paragraph 117, to the case law addressing sadistic conduct. In particular, the authority of Maynard Ellis, in which the Court of Appeal confirmed that the question of whether there was sadistic conduct in the last analysis is one of evidential appraisal by the trial judge. That's at paragraph 34 of the judgment, should you need a reference. And what Maynard Ellis said was that the assessment of whether there is sadistic conduct requires an assessment of both the motivation and the act, the actual conduct itself. And again, if you need a reference for that, it's at paragraph 38 of the judgment. I think I've referred to it in the respondent's notice. Motivation has a part, and it may well be an important part to play, but one has to look at the conduct itself as well. Now, taken together, the learned judge was entitled to conclude that this was a murder involving sadistic conduct. And as I understand my learned friend's submissions, in fact, he doesn't take issue with that suggestion, because he accepts that in respect of Scarlett, the learned judge was entitled to come to that conclusion.
So it was a murder involving sadistic conduct, but Mr. Littler says, so far as Mr. Ratcliffe is concerned, that shouldn't have been held against him as an assister.
Well, this was a classic...
Well, it should have been held against him as a sister, but not so significantly as to bring him with particularly high offending.
Yes, but this was a joint enterprise, and it was a classic joint enterprise in my submission. And therefore, the joint enterprise principles apply to this aspect of the sentencing exercise as much as anything else, in much the same way as it would apply to the 17-year starting point. Although it was Eddie who brought the knife to the scene, of course, Scarlett would have been sentenced on that basis as well.
Putting that another way, what paragraph 3.2 refers to is a murder.
Yes.
A murder
involving
sadistic conduct. And there's only one murder here.
Correct.
And if that murder involves sadistic conduct, you say that applies to both defendants who are party to it, although, of course, their respective roles may feature in the next stage of the exercise, either aggravating or mitigating, as the case may be.
Quite so.
It might be different if one might be different if Mr. Ratcliffe had not known of the sadistic nature of the murder, but he did know.
Well, this is what I was going to come to. This, applying the joint enterprise principles of knowledge, assistance, encouragement, they all apply to Mr. Ratcliffe, because Mr. Ratcliffe did know of Scarlett's sadistic desires, as the learned judge referred to them. They were discussed with him over a lengthy period of time. The messages demonstrate that far from discouraging those sadistic desires, as expressed by Scarlett, he encouraged them, suggesting ways in which children could be tortured. And in the final analysis, not only did he assist in the planning in a way that the learned judge described as something of a project for him, but he was in fact the principal in carrying out the killing, because the learned judge found as a fact, and it was supported by the evidence, that though she couldn't be sure that Scarlett had inflicted any of the stab wounds, although that remained a possibility, she was sure that Eddie inflicted multiple stab wounds. And she also found as a fact that the killing itself was sadistic in the way it was conducted. 28 stab wounds, a brutal and sustained assault, which inflicted far more damage than was necessary to commit the offence of murder. So when you look at all of that together, and when you consider their roles, as my learned, as the learned judge has just indicated, in fact, you have to take into consideration that it was Eddie who was the principal in committing the murder.
What do you say to the criticism levelled at the judge's sentencing remarks to the effect that her reasoning is unclear?
I'm afraid I don't accept that on behalf of the prosecution.
So we're looking at page 10b, I think.
Of the sentencing remarks.
Of the sentencing remarks.
At the top of the page, I therefore find that you both took part in a brutal and planned murder, which was sadistic in nature. It's set out in black and white what her finding is in respect of that. But more importantly, it's a finding in my submission that's perfectly well supported by the evidence. And so it was a finding that she was entitled to make.
And if you read on, at the end of the next paragraph, had I not reached that conclusion, I would have treated the sadistic motives and transphobic comments as significant aggravating features at the next stage. You say that's an indication clearly that she was not treating them as aggravating features, but rather as features which went to the categorisation of the offence at the first stage.
And that's what she explained during the course of her sentencing remarks. It's very clear what she's taken into account at each stage. because she goes on to deal with the aggravating features, which are limited to things such as the substantial planning and premeditation, vulnerability of the victim, and so on and so forth. So in my submission, it's not a submission that this court should accept. In terms of...
That's perhaps nudging you.
Yes, thank you.
The
I'm happy to be
gravamen,
nudged.
of Mr. Littler's submissions, beyond lack of clarity and reasoning, is really that in reaching the conclusion that it was a particularly high piece of offending with a 20-year starting point, the judge just didn't give enough weight to immaturity, mild autism, and so on and so forth. I mean, that's where he started and where he ended. What did you say to that?
She plainly did take that into consideration. There were two aspects, I think, to my learned friend's submissions on that point. Firstly, that she didn't take that into consideration with specific reference or sufficiently, with sufficient reference to the transgender aspect of it, which I can deal with. But then in any event, she didn't make enough of a reduction to reflect those factors before reaching the end point of the sentencing exercise. So can I take the first point first? Because it perhaps comes first in time, the element of transgender hostility. Again, I make the point that the court has, these were matters of fact for the court to determine on the evidence that the learned judge had heard, which included the messages, and also, of course, the learned judge saw Eddie give evidence at trial. So she was very well placed to understand exactly what his abilities and disabilities were. The messages make clear and make good, in my submission, the learned judge's finding that Eddie's attitude towards Brianna was dehumanizing, referring to her throughout the messages as it, as a femboy, as a tranny, as a less than human being. And that element of dehumanization, of course, must have had an effect in my submission on the fact that he then went on to kill her. There are specific messages that I've referred to in my respondent's notice that I can take you to, but it may be that you're aware of the general thrust and tenor of what he was saying. But ultimately, there was direct evidence that he wanted to kill Brianna to see if she would scream like a man or a girl, for example. But turning to the point I think that the court may be more interested in, whether his mild autism may have been a factor that should have been weighed more heavily in the balance at that stage. The first point to make is this: Dr. Diggle, upon whom a learned friend places a great deal of weight, carried out a psychological assessment of Eddie. But one thing he did not do is apply his assessment or the results of his assessment to the evidence in the case. He did not look at the messages and say, well, the way in which he expresses himself in such and such a message may be attributed to the deficits that I find in his mental health as a result of autism. That simply wasn't an exercise that was carried out. And indeed, I think the only reference by Dr. Diggle to the evidence in this case came in his first report, when he made a passing reference to the messages and said that they demonstrated an ability to engage in reciprocal communication. And so when my learned friend asks the court whether it should take placed greater weight on Dr. Diggle's analysis than the trial judge's analysis. In my submission, that's an important point to remember. The judge had to look at culpability in light of the evidence that was before the court and not simply the psychological assessment. And that's a principle that's been made clear for many years. It's in the sentencing guidelines. It was in the case of Coonan that I've referred to in my respondent's notice. But in any event, just taking the medical evidence at face value, the clear evidence was that Eddie's autism spectrum disorder did not prevent him from understanding what he was doing or understanding what he was saying. The prosecution's psychiatrist, Dr. Crawford, did consider the evidence, did consider Dr. Diggle's assessment and accepted it. But he, and this is the page reference I'll give the court now, is on the digital case system, it's M368. It's section 10 of Dr. Crawford's report. Dr. Crawford accepted Dr. Diggle's analysis that Eddie had difficulties with speech, but he had no impairment of functional language. In other words, he had no impairment of his ability to understand language. And that's apparent from the messages, and it was apparent from what he said to the police in interview, and it was apparent from his evidence in court. Dr. Crawford also noted that he had no disorder of intellectual development. The overwhelming evidence was that Eddie is a highly intelligent young man, I should say. And it was Dr. Crawford's conclusion that Eddie had the ability for what he referred to as social cognition, the ability to interpret social information and act appropriately. And again, that's demonstrated by the messaging. And as I've said, Dr. Diggle, insofar as he addressed the point, agreed on that. It was apparent from the evidence and from the interview that Eddie was neither suggestible nor biddable. And just going back to the issue in respect of transgender hostility specifically, the suggestion that he was following the lead of Scarlett or indeed other children was not supported by the evidence. Scarlett didn't tend to use that language about Brianna, and there was evidence in the messages of Eddie conversing with other children using equally derogatory language about children with other particular traits. The thrust of my learned friend's defense of Eddie during the course of the trial was that Eddie was simply going along with something that Scarlett wanted without fully understanding what that was. Now, that defense was rejected by the jury. And so we have a situation where the learned judge reached a finding based on the evidence, in accordance with the medical evidence, in accordance with the evidence that she heard at trial, and in accordance with the jury's verdict. So that's what I say in relation to the transgender aspect of her findings. But moving on, unless there's anything else I can assist with on that point, to the more general point about whether sufficient weight was given to these factors when it came to mitigation. Plainly, a substantial reduction was made to reflect these matters at the point of mitigation. Because, as the learned judge made clear, although there were aggravating features, she made no further upward adjustment to reflect them in Eddie's case, because, as she said, they were balanced out by the mitigating features. And the mitigating features in his case really were limited to his age and his mental health. And so we can see that she has made a downward adjustment, and going beyond that even. During the course of the sentencing hearing, and we have the transcript of my opening, but during the course of the sentencing hearing, there was some discussion about whether, if the court found that there were multiple features that led to the elevated starting point, that should lead to an upward adjustment within the category range. So, for example, if the court found that there was sadistic conduct, should there be a further upward adjustment to reflect the taking of the knife to the scene? This is, I think it's at page 13 of the opening transcript. And I refer to the case of Jugra. And during that discussion, she made plain that given the immaturity of the defendant, she wasn't inclined to do that. So she wasn't inclined to make an upward adjustment to reflect multiple features that would have resulted in an elevated starting point. So one can see from the basic arithmetic ultimately, and these sentencing cases are never a question simply of arithmetic, but just looking at the basic arithmetic from where she got to, she must have taken into account age and immaturity in reaching the end point of 20 years, because there were significant aggravating features: premeditation, the planning, the vulnerability of Brianna, the fact that the offence took place in public on a busy Saturday afternoon in a park. None of those features resulted in a further upward adjustment because they were cancelled out by factors relating to Eddie's age and mental health.
Ms. Hare, could I just draw your attention, please, to page 11, B and C, where the judge, we mentioned it before, returned to the issue about the fact that there were a number of factors which put this case, in her view, into the 20-year category. She says that on the one hand they have been taken into account, but she also says they do, however, have to be recognised in balancing the aggravating and mitigating features.
Yes.
So it may be that to some extent she accepted the submission that you made there.
Forgive me, to some extent she
accepted the submission which you were making, I think, that there were, because there are a number of factors putting this into the 20-year bracket, that was an aggravating feature.
I think what she was saying is that, yes, of course, that's capable of
Yes.
Resulting in a further uplift. But what she said, certainly during the sentencing hearing itself, was, look, I've got to balance that against the age and immaturity of the children I'm dealing with. So it comes to the same thing, I suspect, that she's considering all these different factors and coming to the conclusion that she came to. But in determining how much of a reduction is required, of course, she's got to take into account chronological age and general features of maturity. As far as the autism element is concerned, the sentencing guidelines require her to look at how that affects Eddie's culpability. And I'm afraid the bald fact of the matter is, although Dr. Diggle indicated that there were some areas of deficit which suggested that Eddie operated at a lower age than other children of his chronological age, those traits, in fact, didn't have a bearing on his culpability.
Yes.
Because he understood the nature of what he was doing, he knew that it was wrong, he was able to make a rational judgment, he was able to exercise self-control. All those factors that the Sentencing Council ask us and the courts to look at when considering the impact of mental health disorders on culpability and therefore the sentence that's imposed. So I feel as if I may be starting to repeat myself.
Yeah, Mr. Littler, as I understand it, does not positively advance a disparity argument, but he says as he would put it, slim difference between the sentence of 20 and 22 years imposed respectively on Mr. Ratcliffe and Scarlett Jenkinson demonstrates that the judge gave inadequate weight. What do you say to that?
Firstly, 2 years for children of this age is not a slim difference, in my submission. Secondly, my learned friend, and I make quite properly on behalf of his client, focuses on what Scarlett did wrong during the course of this offending, without making reference to the involvement of Eddie. Eddie was involved in the messaging, involved in the planning, involved
He bought the
in
knife.
encouraging.
He bought the knife. He bought the knife.
He brought the knife to the scene.
He purchased the knife as well as bringing it to the scene.
He told Scarlett that he had the knife. It's plain from the messages that he wanted to use the knife. When they talk about how the killing is going to be carried out, he says, "Can I stab her?" He brings his knife to the scene. He's as involved in my submission as Scarlett, albeit perhaps in different ways. And when my learned friend refers to Scarlett's kill lists, that's not quite right. There was no physical list of people. There were names mentioned in the messages. 2 of those names were brought up by Eddie. So these weren't just Scarlett's kill lists. Eddie demonstrated himself throughout to be just as enthusiastic about what they were going to do as Scarlett. And he's demonstrated throughout in my submission that he knew exactly the nature of what they were going to do. And we know that from not just the physical effect of what he was going to do, which undoubtedly he understood, but also morally that it was wrong. We know that because of the lies that he told in interview, all of which demonstrated he understood the importance of the different parts of the evidence. He had a sophisticated understanding of where the strengths and the weaknesses of the evidence were. So the other thing I suppose to mention on that point is this. As my lady has already identified, Scarlett wasn't without vulnerabilities.
Well, in fact, I just reminded myself, and I was going to give Mr. Littler the opportunity to make any comments, but actually, whilst Dr. Church did conclude that she did not have autism, she did have social conduct dissociation disorder.
Yeah, conduct dissocial disorder with limited pro-social emotions,
which actually the judge treated as an explanation for how such a dreadful murder could be committed.
And linked it directly into her culpability. The lack of empathy, or the absence of empathy, meant that she didn't have that break that other people would have to prevent them committing a crime of this nature. So she wasn't without vulnerabilities. There were different vulnerabilities, but she wasn't without them. And secondly, of course, the judge did draw a distinction between Scarlett and Eddie based on Scarlett's attempted poisoning of Brianna earlier in the sequence of events. It must be said, an event that met with the apparent approval of Eddie, if one looks at the messages. And just one final, perhaps small point. My learned friend is quite right that he introduced the suggestion that Scarlett's culpability was greater because of the abuse of trust. That wasn't a factor that the prosecution had relied on. And that's because in murder cases, the aggravating feature is expressed as an abuse of a position of trust. Scarlett and Brianna were friends, and there was an abuse of that friendship, plainly. But it didn't amount to an abuse of a position of trust. So whilst it may have aggravated the offence as far as she was concerned, not to any great degree in a sentence of this length.
Thank you very much.
Can I assist further?
No, thank you very much indeed. You've also been very clear. Miss Mottram, anything from you?
Thank you.
No, thank you. Mr. Littler.
To just deal with some of the points that have been raised. The observation that Eddie was principal. The conclusion reached by Her Ladyship on sentence, and we agree with this, is that this was a joint enterprise. Her Ladyship, when sentencing at page 4, paragraph G, said this: I am certain that at least some of the wounds were inflicted by you, Eddie. And at page 5, A to B, beyond being sure Eddie inflicted some of the wounds, I cannot be sure precisely who did what. And we concede it didn't really matter from a sentencing perspective. But one should not lose sight of the fact that within Dr. Church's report, which he prepared post-trial before sentence, Scarlett Jenkinson changed her account radically and conceded and confessed effectively to Dr. Church to say that Eddie had started to stab 3 or 4 times and then panicked and said he didn't want to kill her, and that's when she took the knife and stabbed Brianna more times than she can remember, and she went into more graphic detail. Her Ladyship, understandably, came to the conclusion that Scarlett had given so many accounts, you couldn't really believe what she was saying. But I just mentioned that because that is an admission by Scarlett after the trial. It's an admission against self-interest. And I just raise it because it's been suggested that Eddie was the principal, and we submit they were both involved. It didn't really matter who stabbed and how many times. In relation to the sadistic murder, the conduct, the motivation towards, our submission is the same. We've never suggested that it's not an aggravating feature for someone to encourage a sadistic murderer or participate and motivate someone to conduct a sadistic murder. That is an aggravating feature. The difference is on sentence, when one applies Schedule 21, is that you are giving a starting point of 20 years because you are sentencing a sadistic murderer. You are sentencing someone who poses a greater danger to the public going forward, and that is part of the sentence, not just the conduct and the lead up to the offence, but the risk. And as is quite clear from Her Ladyship's observations, they may well have had different motives. It's a joint enterprise, but that doesn't necessarily mean joint motives, and it certainly doesn't mean joint culpability. As regards significant planning, which would also have been a route to a 20-year starting point for a case involving the death of a child, which this clearly was. Significant planning, and the word significant is important when one places that next to the finding of Her Ladyship, where she states quite clearly, and I've raised this before, he was not the driving force behind this. And sadly, all murders require an element of planning. We would submit that Eddie's involvement when he came into this project, as he called it, did not amount to significant planning for him. It would have certainly been a basis for Scarlett to have received a starting point straight away, because it's quite clear from the material she had and the plans she had, and the fact she tried to kill Brianna before, that she had very definite plans. As regards Dr. Diggle, it's right to say with Dr. Diggle's report, as most of the reports do, they are dealing with Eddie at a time when we were considering fitness to plead.
Yes.
And they're also dealing with a time when we were all considering whether his condition may play some part in the trial itself.
I understood that, but there wasn't, as a matter of fact, the exercise referred to by Ms. here in terms of actually looking at the messages, for example, and commenting.
Absolutely, and I can be clear to the court that a decision was made that the messages speak for themselves, and to place before the jury evidence such as this would be, on one basis, quite misleading to a jury with the issues that they had to grapple with. The difference now is we're dealing with culpability, and so just the broad observations of naivety, lack of maturity are very important, especially when you apply Schedule 21, because the court know if you're 15 or 16, the starting point would be 20 years in a case we're looking at. And if you're 14, the starting point is rather less than that. If the judge was dealing with a knife, bringing a knife to a scene murder, starting point would be 17 years. And if it was a 14-year-old, 13 years. A huge difference. And so the broad, simple observation we make is, if we have a case where there is a possibility, if this court can come to a conclusion that we are dealing with an appellant or an applicant who is less mature, more naive than your average 15, 16-year-old, then starting points start to become very important. And it was her ladyship who decided to employ Schedule 21 and move this sentence from 17 years up to 20. If I can deal with my lady's observation regarding Dr. Church, my lady's quite right. If I was making the point that Scarlett Jenkinson was without vulnerabilities, and I did refer to the fact that she was diagnosed at paragraph 179 with a severe form of conduct dissocial disorder. That is conceded. The paragraphs I was looking at with regard to Dr. Richard Church's report was on page 32, paragraph 183. Although Scarlett may have some traits of ADHD and ASD, especially in her early childhood, I am far less persuaded that these diagnoses apply at the time of the pre-sentence assessment. My view now is that it is unlikely that she meets diagnostic criteria. She does not, next paragraph, she does not currently appear to present or report any symptoms of PTSD. And it's over the page at paragraph 185. He talks about the elevated risk of more severe harm in the future to potentially fatal levels, harm to herself, and we would submit to others. Those are the points we were making, and that's the difference between her position and that of Eddie Ratcliffe's. One last thing, I'm reminded, Eddie Ratcliffe did buy the knife. He bought it on a holiday in Bulgaria while skiing. His father purchased the knife for him. It was a hunting knife.
Thank you. Thank you. There are messages about it, aren't there?
Yes, there are. It was agreed.
Where I think Mr. Ratcliffe says to Scarlett, "I've got the knife."
Yes. Is it sharp enough?
Is it sharp enough? Yes, and all of that. Yes.
But it was an agreed basis that it had been purchased on a skiing holiday not long before.
Thank you very much. January, New Year's Day.
And I believe that the jacket he was wearing on the day was a ski jacket that he'd worn on that skiing holiday.
Yes, thank you. Thank you. Anything else? No, thank you very much.
Thank you.
We obviously need to consider very carefully the oral submissions we've heard to supplement the very helpful written submissions. If we are able to reach a decision and produced a judgment, then we hope to do that at 2:30 this afternoon. It may be, as I say, we need to consider carefully, but it may be that we have a full written judgment, and there will simply be a short oral summary of the written judgment, which will be handed down at the same time. But we'll have to see how we go. We will communicate with everybody if that position changes. But at the moment, we'd ask everybody to come back into court, please, for 2:30.
Thank you.
Mr. Ratcliffe, Mr. Rawson, I hope you heard that. The oral submissions have now concluded. We are going to retire to consider whether or not we are able to deliver judgment today. If we are able to do that, we anticipate coming into court at 2:30 this afternoon and proceeding in that fashion. If that changes, Mr. Rawson, we will make sure that communications reach you. I presume you're on your email if there is a change in plan. Otherwise, please could Mr. Ratcliffe be back here for 2:30. Thank you all, 2:30. Mr. Littler, Miss Dear, Mr. Coulson, can I just check you can still hear me? Yes, thank you. We are in a position to give judgment now.
Thank you.
We will be giving a full written judgment, which we will be handing down at the end of my oral remarks. The written judgment will be accompanied by a press summary, and we will make copies of the documents available to you and to everybody in court who wishes a document at the end of what follows. What follows is an oral summary from me of our reasons and our conclusion. What I say in the normal way does not form any part of the judgment itself. The only decision will be that contained in the written judgment, as I say, copies of which will be available. The neutral case citation of the judgment, when it is available, will be 2024 EWCA Crim 1498.
Thank you, Melody.
Mr. Coulson, have you heard that? I am just going to give an oral summary of our decision. And of course, Mr. Ratcliffe will have the opportunity for discussion with you and his barristers at the conclusion of the judgment with the full documents available as well. Please do sit down. This application for leave to appeal against sentence concerns the sentence imposed on the applicant, Eddie Ratcliffe, on the 2nd of February 2024 at Manchester Crown Court after he was convicted on the 20th of December 2023 following a trial, together with his co-defendant, Scarlett Jenkinson, of the brutal murder of Brianna Jai. Brianna was only 16 years old when she was killed. She had her whole life ahead of her. She had some struggles that made her vulnerable, but she was supported by a loving family who wanted nothing but the best for her. She made a real impact in her short life, and her family remember her for her laughter, for being full of life, and as a good listener. Mrs. Justice Yip sentenced the applicant to be detained at His Majesty's pleasure with a minimum term of 20 years, less time spent on remand in custody. Scarlett was sentenced to be detained at His Majesty's pleasure with a minimum term of 22 years, less time spent on remand in custody. On the 2nd of February 2024, the judge lifted the reporting restriction in respect of Eddie, the applicant, and Scarlett, so as to allow reporting of their identities. but a reporting restriction order in relation to the publishing or broadcasting of the names, photographs, or images of any of the other children other than Brianna referred to in this matter remains in place. The factual background. On the 11th of February 2023, Brianna Jai was 16 years and 3 months old. Scarlett was 15 years and 8 months old. The applicant was 15 years and 7 months old. Brianna and Scarlett knew each other from school. Brianna thought that Scarlett was her friend. They had arranged to meet that afternoon in Linear Park. Scarlett and the applicant had been friends since they were 11 years old. They had made a plan to kill Brianna that afternoon at Linear Park. The applicant arrived there bringing a hunting knife with him. He and Scarlett used that knife to stab Brianna 28 times to the head, neck, chest, and back, killing her. The judge found that it was a brutal and shocking murder resulting from a sustained and very violent assault. The case was unusual, not only for the fact that the murderers and the victim were all children, but also for the graphic and sinister messages that Scarlett and the applicant had exchanged in the build-up to the attack and their cold and callous behaviour in the aftermath. For the purpose of sentence, the judge considered a large number of reports about the applicant prepared by consultant psychologists, consultant psychiatrists, an intermediary, a consultant speech and language therapy expert, as well as a pre-sentence report. Following his detention, the applicant was diagnosed with mild autistic spectrum disorder, ASD. Following his conviction, he has developed severe anxiety and involuntary selective mutism. The sentence. The mandatory sentence for murder for an offender aged under 18 when the offence was committed is detention at His Majesty's pleasure, with a minimum term to be served determined by the judge in accordance with Schedule 21 to the Sentencing Act 2020. The judge identified that the appropriate starting point here was 20 years. 1, because the murder involved sadistic conduct by Scarlett, and the applicant had actively participated in it, knowing those sadistic motives. And 2, because the murder was motivated in part by the applicant's hostility towards Brianna due to her being transgender. The judge identified the following aggravating factors. There was a significant degree of planning and premeditation, started by Scarlett, but with the applicant joining in. Scarlett had tried on an earlier occasion to poison Brianna, with the applicant encouraging her to make further attempts. There was an unsuccessful attempt to lure Brianna to Linear Park on the 28th of January 2023 with a view to killing her. Brianna was vulnerable and was picked as a victim because Scarlett and the applicant thought that she would be an easy target. Scarlett abused Brianna's trust in her as a friend in order to lure her to Linear Park, and the applicant was aware of this. And the murder was committed in broad daylight in a public park where other people were around. The brutality of the murder, the use of a knife, sadistic motive, and transphobic motive were all taken into account in identifying the starting point, and so not double counted, but together they illustrated how serious this offence was, even in the context of murders of particularly high seriousness. The judge identified as mitigating factors the applicant's age and level of maturity, which was less than many others of his age, his previous good character, and his progress in detention, good behaviour, passing GCSEs, starting to study for A-levels, and starting speech and language therapy. Having considered the many reports about him, the judge concluded that his thinking skills were less developed than normal in several areas, but that his diagnosis of ASD and associated limitations did not significantly lower his culpability for Brianna's murder. She took into account, however, that his experience of custody would be made more difficult by his ASD, his severe anxiety, and his selective mutism. The judge found that the applicant's culpability was not quite as high as that of Scarlett, and that the aggravating and mitigating factors in his case were evenly balanced. It was therefore not necessary to make any adjustment to the starting point of 20 years for the minimum term, other than to deduct the days spent on remand in custody. The question for the court is whether it is arguable that the sentence passed on the applicant is manifestly excessive. The applicant argues that the judge erred in concluding that the starting point should be 20 years. She failed to reflect his age and his level of maturity when determining it. She gave disproportionate weight to the aggravating features she identified. She gave insufficient weight to his personal mitigation based on his ASD diagnosis and significant impairments in functioning. She failed to distinguish sufficiently between the applicant's role and culpability and Scarlett's greater role and higher culpability. And she failed to give reasons, it is said, that were sufficiently clear as to how she arrived at the sentences of Scarlett and the applicant. The respondent argues that the judge had heard the trial and seen Scarlett and the applicant give evidence. She was in the best position to assess their differing roles, and the sentence that she imposed on the applicant was correct for the reasons that she gave. Our analysis. It is necessary in a case such as this to bear in mind that the principal aim of the youth justice system is to prevent offending by children and young persons. See Section 37 of the Crime and Disorder Act 1998. The Sentencing Act 2020 must be construed consistently with that aim. See Section 58 of the Sentencing Act 2020. In a case such as this, the Sentencing Council guidelines on sentencing children and young persons and on sentencing applicants with mental disorders, developmental disorders, or neurological impairments are applicable, subject to Schedule 21 of the Sentencing Act 2020. As we have set out, the applicant's arguments include, one, that the judge erred in determining the same starting point for the applicant as for Scarlett, and two, by failing to reflect the applicant's age and level of maturity when determining the starting point. Each argument is based on a false premise. When determining the starting point, the judge was obliged to, and did, have regard to the relevant matters set out at paragraphs 3 to 5 capital A of Schedule 21. The respective roles of Scarlett and the applicant were matters to be taken into account when considering aggravating and mitigating factors. We have considered the messages exchanged by Scarlett and the applicant before the murder, including not only those highlighted by the respondent, but also the other messages which provide context. Those messages make clear that Scarlett's motivation in proposing the murder was the pleasure which she intended to derive from Brianna's suffering. The applicant was fully aware of this and actively participated in a brutal murder which must indeed have caused Brianna to suffer before she died. In those circumstances, the judge was entitled to conclude that the applicant took part in a murder involving sadistic conduct. This was a joint enterprise. Further, the judge found as a fact that the murder was partly motivated by such hostility, transgender hostility, on the applicant's part. This court will not interfere with a finding of fact made by the sentencing judge unless the court is satisfied that no reasonable finder of fact could have reached that conclusion. See, for example, Crown against Cairns, 2013, 2 Criminal Appeal Report Sentence 73 at paragraph 10. Having regard to the messages sent by the applicant in advance of the murder, it is clear that the judge's finding that the applicant's participation in the murder was at least partly motivated by hostility towards transgender persons was one which was open to her. In short, the judge's choice of a starting point of 20 years for the minimum term was correct for the reasons that she gave. The judge was then entitled to take into account the aggravating factors that she identified. She did not refer to Brianna's being a child as an additional aggravating factor, although she could have done. She was entitled to take into account that the applicant knew that, to further their plan, Scarlett abused the trust placed in her by Brianna as a friend. As to mitigating factors, the judge again was entitled to observe that the previous good character of the applicant and of Scarlett had to be seen in the context of this very serious offending and the contents of the messages exchanged between them prior to the murder. The judge took into account the applicant's good behaviour in detention and the prospect that he might one day be rehabilitated. The court is pleased to see from up-to-date reports that this positive behaviour has continued, and the applicant is to be commended for his attitude and his constructive involvement in education, therapy, and engagement with intervention programs. The judge rightly identified 3 potential mitigating factors from the various medical reports, including those relating to the applicant's ASD: immaturity, reduced culpability, and increased hardship in detention. She took into account that the applicant was nearly midway through the 15 to 16-year age range, and that his thinking skills in certain areas were less developed than the norm for that age range. None of the reports expressly addressed the question of the applicant's level of maturity at the time of the murder, and several of the reports recognised significant change in the applicant's condition following his arrest and detention. The judge was entitled to have made her assessment of the degree of the applicant's relative immaturity and the weight to be given to that as a mitigating factor, having regard to all of the evidence in the case, including evidence from various reports that the applicant was intelligent, functioned well academically, and knew well that killing was wrong. The judge was also entitled to have regard to the messages that he sent to Scarlett before the murder. Similar considerations apply to the judge's assessment of the limited degree to which the applicant's culpability was reduced by his ASD and associated impairments. The judge had properly borne in mind that the applicant's experience in custody would be made more difficult by his ASD, his severe anxiety, and selective mutism. As to the judge's reasons, she was required to identify the appropriate starting point for the minimum term, the aggravating and mitigating factors, and the appropriate minimum term as a result, reflecting the balance of those aggravating and mitigating factors, all of which she did. She was not required to do more. Having considered all of the aggravating and mitigating factors and the parties' submissions in relation to them, we consider that the judge was fully entitled to conclude, in the applicant's case, that the aggravating and mitigating factors balanced one another out. We have not found it helpful to focus on the difference between Scarlett's sentence and that of the applicant. As reflected in the judge's approach, sentencing children has to be individualistic. 2 years is not a small difference for defendants of this age. And whilst it was appropriate that Scarlett should receive a longer sentence, the judge also had to take account of the mitigating factors in her case, which included a lack of maturity and a diagnosis of a severe form of conduct dissocial disorder. For these reasons, we conclude that the sentence imposed by the judge on the applicant was neither manifestly excessive nor wrong in principle. The proposed grounds are not arguable. The applicant's application for leave to appeal against sentence is refused. Thank you, Mr. Littler. Thank you, Ms. Dear. Now, can I just hand down, please, the full written judgment? Members of the press and anybody else who would like to would stay in court for 5 minutes or so. We'll come back with a corrected version. Mr. Littler, thank you. You have said everything that could be said in this difficult and distressing case. Thank you to your junior. Ms. Here, thank you to you and your junior. Are there any other matters with which we could assist at this stage?
No, thank you, my lady.
Thank you, Mr. Coulson, as well, for your assistance remotely. That concludes this hearing.
All right, so that was the case of UK against now this Eddie Ratcliffe and then the Scarlett girl. I keep forgetting her last name. I don't want to call her Scarlett Johansson because that is not true. But yeah, so it's just a bit of an insight because UK are starting to get a little bit, a bit more open in terms of doing some cases. I'll be covering a bit more cases when there is more downtime on trials. There is one case that I did say that I was not going to cover, but I am very intriguing to cover is the Lucy Letby one. But that one, I need a bigger stream and I need a lot of more investigation because there is a lot on that one and it's a bit of a heavier one. So, but that one is coming up to the surface again because there is appeals and more judgments coming across. And there's also next month, in one of the weeks that I am on holiday, there is a sentencing just near where I live, which I'm going to go to court. I have the day off. I will be going into court. I don't know what time the hearing is, which I'm hoping it's in my morning, your guys's very early mornings, so I'll be back to stream in my afternoons, your morning, like 9 a.m. morning for you guys, and talk about it. How was the experience or anything? If we're not in the middle of a trial, if we are in the middle of a trial, we'll carry on with the trial, and then on breaks or on the lunch break, I can talk about the sentencing or doing the stream. But we'll see when we come across that. But yeah, so this was a case that was quite popular, quite very known in here, and gives a bit of an insight of the UK law system, because it's very different than the US, but they use different words. Obviously, it's the different language. English and American English is completely different, and the wigs, it's all fun. And what I'm surprised is, the three people that are behind the judges, the lords and the lordships, whatever they call them here, they have to stay there the whole time, especially if they are doing the trial. They have to stay there the whole time, for 4 hours or 8 hours. That's a long time. I don't think I could do that. That's but I think it's a very prominent thing to do that. So but still. But anyway, so I think this is gonna be it because my internet is gonna fail soon. I already getting the advice. So I'm gonna leave the stream here. So thank you very much for everyone to come in. Thank you for the likes and for staying here with me. I will be back tomorrow. 8:30 Eastern, because we're going to start watching the Darryl Brooks trial. This was a trial that I did not catch live. I was not into true crime yet at that time, and I missed it. I missed the references. People talk about the references, and I don't know what people are talking about. So now that there is no really much trials going on or anything at all because of Christmas, it's a perfect time to rewatch that case. So yeah, so tomorrow we start with the Darryl Brooks trial. I'm gonna go enjoy my evening because it's 5 o'clock in here. I'm gonna make dinner with the Nightbot, and yeah, thank you very much once again for being here, for the likes, and I'll see you guys all tomorrow. Bye.